Welcome to my channel Final Verdict. Welcome to Audit the Audit, where we break down the who, what, and whether police interactions are right or wrong. This episode is a bit different from our usual format and is part of a collaboration with our second channel, Audit the Court. Today, we'll be reviewing body camera footage from a police encounter, and tomorrow, March 20th, 2025, we'll take a closer look at a deposition from one of the officers involved. You can find that in the description and pinned comment below. Now, let's get into it. On December 15th, 2018, independent journalist Winston Knowles was standing on a public street corner in Roy City, Texas, holding several signs, some of which included profanity. After a complaint was made about one of the signs, an officer responded and approached him.
How's it going? Are you doing okay, sir? You're just not going to answer? We're getting reports that your signs have profanity. Can I check them to make sure that they don't? And then you can stand here all day long if you want to.
He's going to do that.
I'm 7.711. Go ahead and head over here. You won't let me look at your signs just to make sure there's not any profanity on them?
No, sorry.
You what?
No, never mind. Yes, you can go away now. I'm not doing that.
If you are holding up signs for the public to see that have profanity, then yes, you are doing something illegal. I'm just trying to make sure that all I want to do is make sure that what I've been told is not what's on your signs, and then you can stand here all day, like I said. Right here.
Well, this is fine. So,
And I've already heard you say a cuss word once, so.
what do your other signs say, sir? Sir. Two signs. Spirits. Stu? Peace. Some fun.
All right.
I don't consent to any searches or
Additional officers soon arrived on scene. When Mr. Knowles declined to show all of his signs, one of the officers knocked them from his hands, moved them, and looked through them. The Fourth Amendment protects a person's right to maintain control over their personal property. Courts have made clear that a seizure occurs when officers meaningfully interfere with that control. In this situation, taking the signs and inspecting them would likely qualify as a seizure. Typically, officers need a warrant or a recognized legal exception, such as consent, an emergency, or clear evidence in plain view, to justify that kind of action. Here, none of those conditions appear to apply. Instead, the actions seem based on a belief that the signs might contain unlawful content. A court would likely find that this alone does not justify taking or searching through someone's property.
This is
It is. Disorderly conduct.
It's just. He's right.
How you feeling the ID? Put your hands behind your back.
Since he's selling the ID, taking a look at this one.
Oh, that's good.
I would like to speak to the supervisor right now.
The supervisor is the one that's right here talking to you, so.
I'd like to speak to you, supervisor.
As far as I understand, I have not committed a crime today. When we're here answering a complaint and you refuse to identify yourself, that is a...
Mr. Knowles maintained that he had not committed a crime. Officers, however, claimed that his refusal to identify himself during their investigation was unlawful. Under Texas law, failure to identify generally applies only after a lawful arrest, or when someone provides false information. It does not require a person to produce identification simply because an officer is investigating a complaint. In this case, Mr. Knowles was not under arrest at the time, and he was not asked for the specific information the law requires, such as name or date of birth. Saying you don't have physical ID is not the same as refusing to identify yourself. Based on this, a court would likely conclude that no violation occurred.
When we're here answering a complaint and you refuse to identify yourself, that is a crime.
26 on that one, they're good at.
When you're displaying these signs and people are calling because it's offensive to them, that is another crime. So yes, you have committed a crime. You've committed two. You didn't warn me. We don't have to warn you. Ignorance of the law.
I asked you politely to see your signs, and you said, no. Sent to any searches or seizures of my property or my person. Is that your cell phone and tripod? If it's not, I'm gonna leave it sitting here. If it is, I'm gonna take it and put it up so somebody doesn't steal it. If you want to act this way, I'll leave it sitting here and let somebody steal it. Why would you do that? Okay. That's for, we don't own stuff that is. I have a question. What am I being arrested for?
Disorderly conduct. Disorderly conduct.
Officers ultimately arrested Mr. Knowles for disorderly conduct and failure to identify. Disorderly conduct laws do restrict certain behavior in public, including speech, but only under narrow circumstances. For speech to qualify, it generally must rise to the level of fighting words, meaning language likely to provoke an immediate violent reaction. Simply displaying or expressing offensive or profane messages, without more, is typically protected under the First Amendment. Based on these facts, it is unlikely that a court would find that Mr. Knowles' actions met that legal standard.
The failed ID. That's a question. He had off the time to ask things right. You know what?
Nobody even asked me to identify it. All he did that with the head up keys.
Let me explain something to you, young man. We're not holding court on the side of the road with you, okay?
So you're arrested?
We're not holding court with you on the side of the road. Any questions you have, you can ask the jail. Are you
You can get out?
I can't. Roll back over and I'll help you up. I'm not sure if I can do that either. I would like to see your supervisor right now before you assault me any further. We're not. I am being assaulted. I have not committed a crime. I have not committed a crime. I have not committed a crime. Peter, get up. You're hurting me. You're hurting me.
Then get up.
I cannot get
Then
up.
get
like
up.
this. I can't
Get up.
like this.
you up.
I'm trying to get up. That please.
Get up.
Well, assist me up instead
We're
of
trying to help you up.
Lift you up.
See the game. Roll up to your knees and they're going to shoot you up.
Roll up to my knees. I'm offended. Help me to my knees.
We already have one. All over where you are.
Now they'll lift you straight up. Stand up. Okay, help me up. I've committed no crime. I've committed no crime whatsoever. Please get my equipment. Here. So you're gonna leave my shit on the side of the road. Get my equipment. Get my equipment.
Don't tell me what to do.
Mr. Knowles was charged with disorderly conduct and resisting arrest, but both charges were eventually dropped. He later filed a federal civil rights lawsuit related to the incident. Overall, the officer's actions raised significant legal concerns. The initial seizure of the signs appears unsupported by a warrant or any clear exception. The charges for failure to identify and disorderly conduct also seem inconsistent with how those laws are typically applied. At the same time, this case highlights an important point about how individuals respond during encounters. While Mr. Knowles asserted his rights and did not engage in violence, certain actions, like physically resisting or refusing to comply with arrest procedures, can create additional legal risk, even if the arrest itself is later challenged. In many cases, the strongest legal strategy is to comply in the moment and address any potential violations through the courts afterward. This incident ultimately serves as a reminder of how misunderstandings of constitutional protections can escalate routine encounters into more serious legal situations, and why both citizens and officers benefit from a clear understanding of the law.